Today, I'm really excited to give you guys this webinar. What we're going to do is we're just going to wait a few more minutes to allow some more people to come in, and then we'll get started. We are going to get started. Again, for those who have just joined us today, my name is Attorney Hannah Whaley. I work at Eagan Immigration, and today this webinar will cover how to sponsor family members through your U.S. business. So today we're just going to cover a couple different things. First, what does USCIS say about petitioning family? Second, which visa categories can you sponsor family members under? Which categories are most commonly used? What is the process and what to look out for? So the first thing we're going to cover is what exactly is a family relationship. So according to the Department of Labor, a family relationship is any relationship that includes one established by blood, marriage, adoption, no matter how far or distant that relationship is. This includes cousins, aunts, uncles, grandparents, grandchildren, in-laws, and step relations as well. And again, the distance does not matter. This also includes same-sex marriages if they are valid in the place where the couple was married. And the reason that this is important is because with a lot of forms, specifically, they will ask if there's a closely held or family relationship, which is okay, but it is important to know what that degree is and to make sure that you're marking it on the forms. So the popular question that typically goes around is it against the law to sponsor family members with your business? And the answer is no. There's nothing illegal, nothing that USCIS specifically says, or even generally says, that states that family members cannot petition for other family members, whether they're in the United States or abroad, for their businesses. So a common question is, if it isn't illegal, why isn't it popularly discussed? And that's truthfully because there's a lack of understanding around how to do it properly and what that means. So USCIS does not state anywhere that sponsoring family members for employment is illegal or against the rules. However, it is extremely important that certain things are followed, and it's really about the regulations and the way that you're going about it. And the main things you want to look at is compliance. That's with the Department of Labor and with USCIS, a good faith effort, and we'll go into a little more detail as to what that means in certain categories, whether there's a true job offer, and honesty, because again, on the forms, it does ask you whether or not this is a family member or a closely held relationship. So it's always important to discuss and disclose that so that USCIS is not questioning the validity and the honesty around your application. Compliance is key. So the good thing is that USCIS does not narrow down to any specific category. With USCIS, as far as what visa categories you can apply for your family member, that means you can do H-1Bs, you can do O-1s, you can do Ls, you can do perms. It doesn't matter what category you would like to sponsor that employee for or have your family sponsor you for. What is important is following the rules and guidelines. Specifically, what USCIS wants to see is that you're adhering to deadlines, you're adhering to the rules and regulations for the specific visa category or employment-based green card. They want to see that all the job descriptions are clear and accurate. They want to see that you're ensuring that all applicants fully meet the requirements by regulation, and we'll talk about the timing of that as well. And that you're testing the market in a fair and accurate manner. And that's for anyone who's engaging in an employment-based green card process, because testing the market is a required aspect of that. So which categories can you use? As previously stated, any sponsorship category works so long as your family member has a legitimate company and can prove the legitimacy of that company in various aspects of the business, profit, and job opportunities. For a lot of people, they get a little weary and they're like, okay, well, what do I need to share? Typically, this means you need to be able to provide tax information from prior years. And that's just because it is important to show USCIS that the company is legitimate and that there's an ability to pay the sponsored individual and applicant. Another thing, although this is not clearly or specifically outlined by USCIS, the family member who has the company should be a legal permanent resident or a citizen. And the reason that I state this is that it's going to be hard to show USCIS that an individual who does not have a permanent residence will also have the ability to petition someone for a permanent residence. So it is important to make sure that individual, again, is a legal permanent resident or a citizen so that they're able to petition for you, or so that you're able to petition for your family members. So which categories are most commonly used for petitioning family members through employment categories? There's it's really three big categories. The big and the best category, in my opinion, is perm sponsorships. Perm sponsorships, that is an employment-based green card pathway where employers go through a labor certification process, recruitment, and other things that we will discuss shortly to show that they tested the market and they are now able to petition for those workers because they are unable to fill that shortage in that need within their company. And again, this is the best category in my opinion because it's for a green card. This means you're not worrying to have an employer or your family member have to renew yearly or show temporary need or what have you. That typically happens with those non-immigrant temporary visas. Now, the H-2A and H-2B are two big categories that are used for temporary visas for family members. And that's because you're able to get your family member here and do short time work, and then they return. And as long as they stay home for the home residency requirement of 3 months, they're able to apply for a new H-2A and H-2B and come work again. And for this category, it is not a green card, it is a temporary visa. And although it can be extended for up to 2 years, you typically see the validity period on these visas to be a year or less. And that's because they are focused and they are approved on the basis of a temporary need, whether it's seasonal, intermittent need, peak load. And the reason I find H-2As and H-2Bs to be less of a benefit is that you're going to have to do regular renewals. You will have to constantly show USCIS that there is that need. And the good thing about the perm versus the H-2As and H-2Bs is perm, you just test the market with recruitment and different ads showing that you advertise, while H-2A and H-2B, the employer truly has to show that this need exists for the specified time that they're trying to petition you for. All three are fabulous categories, but it really depends on what your goals are or what the goals are for your family member that you're petitioning for. So perm sponsorships, there's two big categories that most families and just businesses look into, and that's the EB2 and the EB3. The EB2 is for advanced degree professionals. And if you've attended any of our other webinars, we've had a webinar on EB2 NIW. EB2 national interest waiver is another form of the EB2. The big difference between the two is that the national interest waiver is for those who are working in a field of national importance. Therefore, they don't need an employer and they don't need a job offer. For individuals who still meet that bachelor's plus 5 years, that master's degree or higher, or exceptional ability, however, they work in a field that doesn't have that national importance or that high growth rate, this is where the perm sponsorship comes in really handy. So in this situation, a family member or a family business can sponsor that individual with a technical background, so long as they have one of these criteria of the bachelor's plus 5 years, the master's degree or higher, or exceptional ability. However, it is important that the individual has those skills at the time of starting the entire perm sponsorship, or it can affect your ability to be approved. Now, with the EB3 unskilled, which is the most popularly used one, that is for any work that is 0 years of experience up to 2 years of experience to actually be able to do that work. A lot of people love this category more if they're trying to sponsor younger family members or those who want to come to the US to eventually go to school. The EB3 category is perfect because if you have positions in your within your company that require less work, or they don't require degrees or maybe no experience at all, you're able to petition and not have to worry about really measuring up that experience, doing degree evaluations, and other requirements that are typically associated with this EB2 category of the advanced degree professional. The perm process. This is a general overview because the perm process can be a little difficult to understand. But first, the first part of this process is the Department of Labor. Now, the Department of Labor, what is required is that the employer must submit something that is called a prevailing wage. The prevailing wage document is a document that is submitted that specifies the job title, the job description, the requirements, degree evaluations, what essentially the employer requires for an individual to complete this job, and any foreign equivalency that may also work. This includes years or skills. This could be as technical as a nanny being able to do CPR work. That is what must go into this prevailing wage document. And it must apply to the specific area. So the employer is also stating where the individual will work. And if you have a business where an applicant may work or an employee works in different locations, that's not an issue. You can also put that on your prevailing wage. However, once you submit that, which takes about 5 to 6 months, you get something back called a prevailing wage determination. That determination provides the employer with the minimum that they can offer to pay anyone for that job. That means they can, if it says $7.15, and the person they want to sponsor, they want to pay $9, they have the ability to offer it at $9. They just cannot go below whatever the minimum wage is that is provided there. However, whatever wage they decide to offer their employee, they must also offer in this recruitment phase. And that is what happens next, is recruitment. So what the employer does is they now take this prevailing wage and they engage in recruitment. Recruitment is mandatory and required by the Department of Labor, and it only happens in this phase. So if you've done any of these things before and you're an employer, do understand that you will be required to do it again if you would like to petition for a family member. So in the recruitment phase, what happens is that the employer must engage in mandatory recruitment, which includes newspaper ads, SWA orders, which is state workforce agency job orders, online posting, notice of filing. But specifically for families, you want to go a little above and beyond because you already have the fact that you're sponsoring a family member. So what I like to say is, for recruitment, when it comes to family businesses, go above and beyond in your recruitment efforts. Don't only do the mandatory. However, after recruitment is done, you're able to now go through the labor certification process. This is a process where you actually go online and you fill out the ETA 9089, and you're putting in the information for each employee that you would like to sponsor underneath that job title. As well, you're inputting the recruitment information as far as the dates that you did your job order and all of the necessary and mandatory recruitment into it. At that point, the Department of Labor will analyze whether or not your recruitment effort was correct and it followed the guidelines, whether the applicant actually meets the requirements that were outlined and if they met them at the time that this process started, and they will either certify or deny. However, if your labor certification is certified, you now are able to move on to USCIS. And at the USCIS phase, you take your certified labor certification, your approved labor certification, and you file an I-140. Well, the employer files the I-140 and you get your approval. After that, you either adjust within the United States or you go through consular processing, which means that you go through the National Visa Center and you have to do your interview and everything outside of the United States. So what does the Department of Labor look at and consider when reviewing your application? They are looking at a lot of different things, but the overall theme is legitimacy. That is the main goal that we're looking at. So the first thing they'll look at is whether the petition for a family member influenced the hiring decisions. Was the family member any part of the review process of those who did apply, if anyone applied during recruitment process? Next, they look at whether or not the family member owns part or all of the company, because they understand this can influence the way that the job offer was created, which is why I say it's very important to go above and beyond in your efforts. Next, they will look at whether the applicant is uniquely qualified. I don't want you to think that, oh, this means that the job description needs to be extremely unique. That is not what they're looking for. What they're looking for is, was the job created and tailored specifically to the individual? And that is not what USCIS wants to see. Next, we look at whether the job is essential to the operations, or again, is it simply created for the family member? This ties to that first one. We want to make sure that this is a job that either makes sense with your family business or has been offered before, because it is hard to show legitimacy if it is a role that is created out of thin air. We want to show USCIS that it is a legitimate job offer and that there is a need that existed prior to sponsoring or petitioning for that family member. And lastly, whether the job is legitimate and was offered and needed, yes, prior to filing for the family member. Again, the overall theme that the Department of Labor and USCIS will be looking at is this legitimate in various aspects? So that's really what you want to focus on. So what the employer must show about the employee, it's not too much. It's specifically that the family member meets the requirements. That is key. So if you require a master's degree and you want to sponsor a family member and they receive their degree abroad, I say before even engaging in the entire process, get that degree evaluation early, because you don't want to be in the position where a master's actually equates to a US bachelor's. And now you have an employee that doesn't meet the requirements that you sponsored for or applied for in the beginning of the process with Department of Labor, because at that point, you've now wasted about maybe 6 months to a year. And that's the worst thing with this process, because even though it's lengthy, you want to make sure that compliance in every single requirement is specifically as you would like it to be. Second, that the family member met the requirement prior to the beginning of this application. Third, if there's job history, proof that the family member had the experience adequately to fill this role. Now, with this one, we want to see that happen prior. And one thing that we run into a lot of times with employers is that they'll have an employee, a family member that received that experience with them. That is not what USCIS wants to see. They will not count that as qualified work experience. So what you want to make sure is that that family member, if experience is required, gain that experience independent of that family business. Next, they will look at whether the family member possessed that education to adequately do the duties. That similarly goes with that degree evaluation. You want to make sure that the degrees equate early on so that you're not getting too far into the process with something you can't work with. And lastly, the family member has references that are unrelated to vouch for his or her work. That is extremely important, because if all of your references for your employees are family members, they're going to question the validity and likely, just to be pretty frank, deny it. That you want to show that, again, any requirements that are put into the prevailing wage that the employee had prior to and independent of the family business. So now we're going to talk about the H-2A and H-2B process. It is very similar to the perm process, but it's a lot shorter. So it's just a condensed version with a few extra pieces to it. So just like with the perm, you have to submit that prevailing wage to the Department of Labor. But after that, you're immediately preparing that job order and then the statement of temporary need, because with these two visas, you have to show that there is a temporary need, whether again it's intermittent, seasonal, peak load, you have to show that. And then that form 9142B is that temporary labor application. After you receive that prevailing wage, you actually submit that application and that job order because it has to be verified and approved by the Department of Labor. That's the only big difference in this situation. Now, after you receive a notice of acceptance, that's when you're able to engage in those recruitment efforts, the newspaper ads, notice of filing, job orders. But again, that happens after you receive that notice of acceptance. And then once that's done, you submit your recruitment report and wait for certification of that temporary labor certification. And then once that is certified, you're able to submit the I-129 to USCIS, while the adverse for the perm is the I-140. And the difference is, again, this is for temporary employment, while that perm is for long-term employment for a green card, as opposed to these are visas that you'll have to regularly renew. Processing times, because I know this is the biggest question that everyone wants to know, is how long will it take? Now, keep in mind, these processing times are the processing times after you've already gone through the Department of Labor and you've already received an approval and certification of your labor certification, your ETA 9089, which is your labor certification, right? So keep in mind, that's about a year process, possibly a year and a half to get to this phase. However, once you're here, depending on the service center, the EB2s are taking 7 months at Nebraska and 8.5 months at the Texas Service Center. The EB3 is taking 7.5 months and at Nebraska, and is taking 8 months at the Texas Service Center. Now, the H-2As and H-2Bs are a little different because, again, they're temporary. And as you can see, the temporary time's a lot shorter. Here, the H-2A is going to take 15 weeks right now. As of this week, that's what it's taking at the California Service Center. For the H-2B, California Service Center is showing 1 week and Vermont is showing 5 weeks. As you can see, the time frames are a lot different. But the big thing you want to remember when it comes to this is that you must go through the full labor certification process before even getting to these phases. And because of that, that's why the perms are going to be a better bang for your buck, because you're able to get that green card as opposed with the H-2A and H-2B, where you're going to have to do those regular renewals. So that is the end of today's webinar. I hope you guys enjoyed this. I hope you guys learned anything. If you have any questions, you can feel free to shoot me an email at hannah.whaley@eaganimmigration.com, which is located at the bottom of the screen. If you watch this and you either think, I have a family member I would like to petition for, or even the vice versa, where you have a family member that you would like to petition for you, definitely sign up for a consultation and use the code Eagan webinar in all caps to schedule your consultation so that you're able to waive that $200 fee. But thank you so much for attending today's webinar, and I hope you guys have a great rest of your day.